Hello everyone, welcome to GNU According to CD, that is Government of National Unity. So guys, the Home Affairs or the Department of Home Affairs, the Minister, Dr. Leon Schreiber, today briefed the Home Affairs Portfolio Committee in Parliament, basically giving a wonderful, well put together presentation regarding the future of South Africa when it comes to this department, citizenship, as well asylum seekers, as well as immigration, tourism, you name it all, they talked about it. And of course, there are going to be some policies that are going to be repealed, meaning laws that are going to be repealed that seems to be working against South Africans, especially when South Africa is taken to court. And as a result of that, South Africa loses to foreigners, basically taking our home affairs to court. And that is why we had that guy, whatever his name is, of that NGO, basically threatening South Africa that if you're not going to allow us to have political parties in South Africa, we are going to take you to court. Because the constitution is the supreme law of the land. Yes, it is the supreme law of the land, but our supreme law of the land, no one else's. But because the constitution itself has some wordings, for example, South Africa belongs to all who live in it. So meaning that you can leave your country wherever you come from, as long as you are in South Africa belongs to you too. Instead of saying every citizens, it says something like someone or anyone. Those are the words that are going to be amended so that they are specific as to who South Africa belongs to the citizens. So that way you don't go to court and the court says, well, this word is it has a lacuna or it has whatever, and as a result we lose to the foreigners. So all of these things are going to be taking place according to this portfolio committee. But I just took an abstract that I felt it's so important for South Africans to listen to. Please pay attention to this presentation, this particular presentation. And then we are going to take this presentation in small bites with following videos. Because I feel like there is something that needs to be understood on what was said here. Right now, it's a whole chunk of it. I'm going to cut it in bite sizes, and then I create videos out of that so that you comprehend, we all comprehend what exactly is being said here. And let me tell you something, what is being said here is to the best interest of South Africans. Because they talk about, this gentleman talks about citizenship, he talks about tourism, he talks about asylum seekers, he talks about first safe country principle, and etc. and so on. And also some shocking stuff as well that he talks about in his presentation that I feel we need to talk about as well with small bite videos. So we are going to be stuck on this particular presentation for probably 2 days until everything has been ironed out. Then we go to Dr. Schreiber's own presentation himself, because I felt there as well there's some things that he said that South Africans need to hear. This part of the video is for South Africans. If you're not a South African, you are not welcome at this point. You'll be invited when I'm going to do the Dr. Schreiber presentation. For now, this is for South Africans to understand what's going on so that you can also make your own opinions and add to this, to the minister, through a video or through a written submission to the Department of Home Affairs, or whichever way. All right. So yeah, please listen to this. It's very important all the way to the end. And then from there, I'll just take it in bite sizes. All right, cool.
Thank you, DG. Thanks, Chairperson, Minister, and honorable members. So as DG and Minister have indicated, the purpose therefore today was to take the portfolio committee just to note the process, and as DG has indicated, the number of areas that I'm not going to speak. So the process in relation to the white paper, Chair, I just want to take the members just one step back to say that when we conceptualized the white paper on citizenship, immigration, and refugee protection, it was because in the past, Cabinet had approved a white paper on international migration. But owing to a number of developments that see people who carry certain immigration documents like visas, permanent residence, that creates also a pathway to citizenship. So it was therefore imperative that we look at actually creating a legislation that covers all those three areas, because we also have refugees who qualify for citizenship at some point. So therefore, the issue of dealing with one legislation and repealing all the others was quite important. So we just highlight here the base documents that we utilized, including that cabinet-approved international white paper on international migration in 2017, and then the other legislation that are relevant to that. We went through a process of the green paper in 2021-22, where we had a lot of extensive consultation. We went to various clusters in government, and also, obviously, as DG has indicated, in the two previous financial years, there was a ministerial report on the issuance of visas and permits that was highlighting a number of areas that we needed improvement. And then the minister's comment on the issue of Operation Volunteer that led to the revision of the white paper. And then in the previous financial year, we had to go undertake a process of public consultation across the country with various stakeholders. The recent one, which we did also early this year, was a workshop on international migration with mayors and traditional leaders, which was held in Boksburg. So some of the key policy and legislative reform, I think Minister has made an indication on that. I'm not going to repeat on the issues relating to Vulindlela, and also the introduction of the remote work visa and startup visas and the trusted employer scheme. And also one of the key areas around the issue of enhancing the travel into South Africa is the creation of the electronic travel authorization in order to enhance the visa. Most countries are doing that. For an example, the UK, they do that for certain countries. If South Africa, for example, we've got a number of countries that are visa exempt. So meaning that if we were to introduce an electronic travel authorization, in other words, we're giving a notification ahead of time who to expect, even though they don't have to bring a visa, but the fact that they actually notified in terms of that electronic travel authorization. When we look at the UK, for example, they also charge about £10, for somebody to apply for that. Then the next one is around the one-stop border post policy. This white paper has already been approved. There are certain obvious components of the policy that require legislation to be passed, but also there are those that allow us to start engaging with neighboring countries in terms of creating a process to establish common control zones in the one-stop border post, and also the OSPP has since been tabled in Parliament after Cabinet passed it last December. And Chair, I think this one on immigration amendment, we have been dealing with the issue of Section 34.1B and D, which obviously was declared unconstitutional by the court. So again, that has since been tabled in Parliament. So all of these, obviously, are current policy and legislative reforms that are currently underway that need to be taken into consideration, as the Minister indicated, that this gives rise to the amendment to a certain part of the policy in order for us to draft the legislation. So at a high level, Chair, I'm not going to deal with some of the specifics because we thought we should just summarize the issues that are coming out of white paper without being exhaustive, but just to indicate the context within which this white paper was developed, and that it was approved, obviously, by Cabinet, as Minister has indicated. There were a number of consultations that I've also made reference to. But also, Chair, just to emphasize the point, as the Minister did indicate, that the complexity of this is at a high level. So therefore, issues around constitutionality become very important so that we don't create a legislation or policy that will be not be in line with our constitution. So there are a few policy positions that are contained in the white paper, which will just at high level again talk about those particular areas. Chairs have indicated on citizenship, the major policy reform that we are dealing with is that the white paper recommends that the Citizenship Act, Birth and Registration Act must be repealed and be included in single legislation dealing with citizenship, immigration, and refugee protection in order to remove some of the contradictions in the path towards citizenship. So that's one area. And the second one was around the criteria for granting of citizenship needs to be reviewed. Other countries obviously have developed a restrictive naturalization approach, so limiting those who contribute to the economic development of the country. In this instance, ours was more of an academic exercise of an administrative progression that you get work visa or study visa, you move to a PR, you move to citizenship, sometimes attracting people who are not contributing positively to the country. Because also what this leads into, pressure on social protection, where, for example, the countries ought to provide, whether is it old age social protection grants and other related. So those resources being constrained, therefore creates huge challenges to the country. That is why ours is to say those who are contributing positive in terms of critical skills, therefore they're quite important. Chair, this slide just shows the current types of visas that we currently have, which we refer to obviously under the Immigration Act. Then we've got functional services, which are temporary waivers, and then the categories of PR. This is on the right-hand side, Chair, just to show permanent residents that there are those that we get through Section 11(6), general work, criticals, and so forth, and also the sort of what one would regard as permits under the Refugee Act, which is asylum seeker visa and the refugee permit. So as Minister has indicated, we need to obviously align with some of the changes that the Genesis report is talking about in order for us to ensure that we either scrap certain types of visas and also or improve some of them and introduce some of the new visas like the remote work visa. So as we review these, the new ones obviously will be coming on board, and then we'll be removing obviously those that we believe that they are not making economic contribution to the country. So the first part that we are raising as a major policy reform is that the number of years that a foreign national has resided in the country will no longer be a main determining factor for granting permanent residence. Periodic invitations for qualifying foreigners to apply for permanent residence will be introduced together with a point-based system. Then the policy framework also affirmed the use of critical skills lists to attract international migrants with skills and qualifications that are in demand. I think this is quite an important area. Also, the introduction of a limited duration permanent resident permits linked to obviously minimum investment. And also the policy framework must provide for the establishment of the Immigration Advisory Board that will advise the Minister on policy and legislative matters. In the current legislation, there is a provision for Immigration Advisory Board, but we are saying that must not be lost, because I think how it was constituted previously and what the Minister's vision is to be able to attract the kind of individuals that will be able to have the required expertise to be able to help us to deal with these issues, and also at a distance, at arm's length, and be able to advise looking at what international practices are. And also, the policy framework also legislation requires that an establishment of immigration courts chairperson. This will obviously be a matter that we'll have to deal with together with the Department of Justice, because I think if you look at the issues relating to immigration, the issue of interpretation of some of the legislation in relation to immigration, there's been a number of challenges that we've had. For an example, when the Section 34 was declared unconstitutional, one of the issues was that if people are arrested for deportation, we need to first to get a confirmation from the magistrate. So that created huge challenges in terms of the courts. At some point, magistrates were not willing to help in that regard. So if you're dealing with immigration courts, therefore, you are able to create a space that they are specifically for that particular area. Obviously, that comes with some of the costs that will be associated with that. Then the last part of this section is in around the border management authority. We are saying that when we look at some of these policy reforms that we are proposing, obviously they will impact on the BMA legislation, so we will need to just to review it to align with the new policy reform. Chair, this slide, we just brought it in just to demonstrate that under refugee protection, it's just to demonstrate the trends that we have had. In 1998, when the legislation was enacted, the South Africa registered about 11,135 asylum seekers who applied for refugee status. And again, that number kept on continuing until the 2008 economic meltdown, where that number actually went up to over 200,000 in 2008 and 2009, when we saw a huge migration to the south because of economic meltdown. And interestingly, when you look at this number, a majority of the people who applied for asylum during that period, and actually across the years, the approval rate of asylum seekers as confirmed refugees, it's sitting just below 6%. So about 94% of all those who claim asylum, actually those cases are found to be maliciously unfounded or abusive claims, so to say. So what then happened in this period, which I always want to give context around people when you look at people who are carrying asylum papers, is that the legislation at the time required that the Refugee Appeals Board, which is currently now called the Refugees Appeal Authority, at the time the legislation was saying members of the board need to sit as a quorum to hear an appeal. Meaning that if you have 5 members of the Refugee Appeals Board, they must sit so 3 of them must hear one matter. Now, if you're sitting with over 200,000 matters or applications for refugee status after the first process by a status determination officer has been exhausted, the Standing Committee on Refugee Affairs has confirmed that this application is maliciously unfounded and abusive, then the person goes to the Refugee Appeals Board. So meaning that if members were to hear 20 cases a day, it would mean that in a week, which is a 5 days, they will probably hear only 100. So meaning that backlog kept on continuing. Hence, these people who were claiming asylum, they kept on then renewing their asylum seeker permit every 6 months, leading to some obvious staying for up to 10 years in the country. And then also in the process, they have children, they have businesses. By the time a person gets here and is thrown out, the person is now expected to raise another claim around the interest of the child and many other related matters. So that is why we are saying in the new legislation, we need to look at the convention to ensure that when South Africa entered the 1951 Convention relating to status of refugees, we entered it without reservations. So we are saying South Africa must therefore consider the inclusion of the reservations in the Convention and the 1967 protocols relating to refugees, status of refugees. But that must be done again in line with our Constitution to ensure that we don't shoot ourselves in the foot by actually taking certain reservations that would be found to be unconstitutional. So that's a point that I think the minister is also trying to emphasize. So the new legislation also must enable the country to refuse the admissions of persons whom there's reasonable grounds for regarding as a danger to the security of the country. Again, we have had cases where people have committed atrocities in the countries of origin, coming, claiming asylum, and South Africa being seen as protecting fugitives, international fugitives that are wanted by what we call international law enforcement. So we work obviously cooperatively with Interpol and other agencies to ensure that such individuals. So we're saying that we need to be able to reject such asylum on the basis of that. The interesting issue, another chairperson that we want to, and members that we also want to look into, is the introduction of the first safe country principle as a precondition for admitting asylum seekers who have transited through safe countries. I mean, we receive asylum seekers from thousands and thousands of kilometers away, and who have passed certain countries. Some will fly to certain countries connecting to South Africa, and then they claim asylum. So this has become an important issue to say that are we dealing with genuine asylum seekers in this instance, or it's just a question of economic migrants who utilizing a particular route to legalize themselves in South Africa? Those are some of the critical areas that we need to look into. Chair, there's a trend that we've also been seeing is that when somebody is illegal in the country, when they are being arrested for transgressing immigration laws, then they claim asylum. So we're saying asylum seekers in that instance must show good cause for their unlawful entry and presence in the country before we can deal with that particular matter. So I think it's quite an important area also that we need to look at. The last 2 point, Chair, is around refugee reception offices that must be located at the ports of entry in line with international practices. Because in many countries, if somebody comes to the port of entry, they claim asylum, the matter is processed there because the refugee reception office is at the port of entry. Fortunately, with us, we only have one refugee reception office, that is those that we have port of entry in Musina. The rest of them are inland, in Pretoria, in Cape Town, in Gqeberha, in Durban. So most of those are processed close by. Well, with those coastal towns also, do not receive much asylum seekers that come through harbors, but we receive mainly, or seaports, we receive mainly through airports and also land ports. So those are some of the areas that we need to look into. And then also, we also need to reconfigure and capacitate our refugee status determinations and appeal structures in line with international practice to ensure that the type of people that you appoint as refugee status determination office, some of them are legally qualified to be able to deal with those particular matters. And then to ensure that obviously the appeal processes, again, we don't want to trample on the Constitution because in terms of PAJA, as we issue out administrative decisions, we need to be able also to give reasons around. That's why the administrative justice compels us to be able to do that. So, Chair, as I conclude, therefore, it's just indicating that as a department, we are identified areas that require further strengthening of the approved white paper, and also to look at the government of national unity priorities, the medium development plan, and also the operational Philindlela report and Genesis. This obvious necessitates that we improve this particular white paper. So we are currently working on the supplementary policy paper that will be submitted to the minister by the end of this current financial year. So, as I said, the supplementary paper will also take into consideration the legal opinion which has been commissioned by the department. And also, Chair, we had tabled in front of the committee and Parliament in March this year an annual performance plan that has performance target, including to this area of developing a bill for citizenship, immigration, and refugee bill. And therefore, it will mean that we are going to be reviewing this particular target in line with the provision that has been made to all government departments that they can actually review their 24-25 annual performance plan to take into consideration the priorities that have emerged out of the seventh administration. So that is currently being undertaken and will be retabled back to Parliament before the end of October 2024. Thank you very much, Chair. That concludes our presentation.